So, wow, I'm not teaching this quarter, and I both feel guilty about it, and I missed being with y'all. So this is a nice break from staring at the screen and hoping words will come out. They do come out. I had a conversation with someone in the room. I won't say who about this. So I wrote like 20,000 words over the first 4 weeks of the quarter. So I go, that's progress. Are they any good? Who the hell knows? Okay. So most times when I'm in the classroom, I feel like I make progress. All right. So the original conception behind these talks, as I understand it, was Chicago's best ideas. Was not that you would come in and talk about your own ideas. Those have to be Chicago's best ideas, they're mine. But rather you would talk about one of your colleagues' ideas. Someone currently on the faculty, something from the past. So I'm gonna embrace that reasonably hard, at least for a chunk of the talk. Frank Easterbrook wrote this paper in 1984, The Limits of Antitrust. I was at a conference at Gleacher, the Stigler conference, Thursday and Friday. And this paper came up there. I guess I brought it up, but other people did as well. This is a lecture that Frank is giving, I guess at the University of Texas. Yeah. And he starts with this proposition. The goal of antitrust is to perfect competitive markets. What does this mean? So here's what I want to do in the talk. 3 arcs. So I want to sort of set up the world that Frank was staring at, right? Papers are all written in context. You see something, you don't like it. I don't say the best reason to write a paper is to be angry about something, but it's good to feel a certain amount of energy about what you're engaging with. So we're going to set that world up a little. I'll just sketch that out, and for those of you who were, and I know a few people in the room may have been at the Stigler conference, you'll see, I've seen some of those slides before. Okay, that's part 1 of the talk. Part 2 of the talk is, I do want to read Frank's paper. That was part of the reason I wanted to give the talk, was to go back and see the paper, and so we'll work our way through that some. I absolutely want to do that. And then part 3 of the talk, I'm going to take the sweater off, it's a little warm. Part 3 of the talk is I want to come to the current era and say, okay, how should we think about the limits of antitrust today? What do we see? So that's the arc. I should say, if you've got questions, jump in. Just, let's not wait until the end. There may be no end. I kept wanting to build more slides. I saw slides I could have built this morning, didn't. I had a little few this morning. So jump in, and we'll just get to where we get. Okay, that's the mission. So I start, and for those of you who took antitrust from me, you've seen this slide. I really start at the beginning. Senator Sherman introduces a bill. As you can see, this is August 14th, 1888. It goes to the Finance Committee, which he ran. So obviously there's a committee structure in Congress. And the bill, and this is the full bill right here. I'm just going to give you the first 12 lines of it. This is it. This is really the genesis of the Sherman Act. This is where it starts. The Sherman Act. Why do we call it the Sherman Act? Because of John Sherman. Sherman, right? Okay. And he's got a couple of ideas here. He's focused on joint activity, arrangements, contracts, and the like. He's got 2 targets: things which prevent full and free competition, things which advance the cost to the consumer. Full and free competition, advance the cost to the consumer. Now, none of that language actually makes it into the Sherman Act itself. Sherman loses control of the bill. I took a creative, I went to school in the summer when I was a kid. I took a creative writing course one summer after the summer of 3rd grade. I was a little geeky, but you knew that already. In the creative writing course, we did this exercise, which was wondrous and awful at the same time, where you would start to write, and you would write for 5 minutes, and then you would pass the story to the next person. They would write for 5 minutes. Next person, 5 minutes. And this sense of loss of control over your story. Oh my God. Well, that's what happens to Sherman here. He's got a story, he wants to tell it, it's in the Finance Committee. He loses control of the bill. It goes into the Judiciary Committee, and what comes out of it is very different language. Language we know, love, I don't know. The language we certainly know about restraints of trade, Section 1, combinations, contracts, conspiracies, and restraints of trade. Section 2, monopolization, single firm activity in the main. But the starting point here really focuses on this idea of full and free competition advance the cost to the consumer. Part of the fighting issues in antitrust today, part of whatever limits of antitrust, are about something we call the consumer welfare standard. I'm going to talk about that a little bit here. But it's in that language, consumer doesn't make it into the actual Sherman Act, even as it's there at the beginning. All right. Then this goes on. I guess I am giving you the rest of it. Oh, I remember why I'm doing this. What damages do you get? Any person or corporation injured or damnified? I always love words that I go, what? What is that? Damnified. It seems like fire and brimstone and all of that. Is that the verb form of damaged? I don't know. I would say damaged. Any person or corporation injured or damnified. Double damages. Okay. All right. Where do I want to go? So Bob Bork, Judge Robert Bork, famously, as you must know, I assume, nominated to the Supreme Court in an epic confirmation hearing he did not get through. That was, I think, the last confirmation hearing where someone said, "I'll tell you what I think." Right now, you just navigate confirmation hearings, right? Okay, Bork wanted to discuss. That was a bad strategy. Bork, a graduate of the college, graduate of the law school. Okay, well educated. He writes this paper in 1966, publishes it in Journal of Law of Economics, which is one of ours, Legislative Intent and the Policy of the Sherman Act. My conclusion, congressional record. Congress intended the courts to implement only that value we would today call consumer welfare. To put it another way, the policy the courts were intended to apply is the maximization of wealth or consumer want satisfaction. So this consumer welfare standard, which is, has been central to how we have approached antitrust in the United States, Bork really puts a flag in the ground, says I can get that out of the history. That's contested. That's not our job today. As soon as he says this, though, consumer welfare, you sort of want to know, well, Bob, what do you mean by that? And he says, well, to put it another way, I'm sorry, another way? What, is this different? I don't know. Maximization of wealth, consumer want satisfaction. Well, maximization of wealth, part of what I want to make sure we see here is what work does the word consumer actually do in the consumer welfare standard? And maybe the answer is sort of none. What work does the word welfare do? Maybe sort of none, right? Maximization of wealth. Okay, so that's what he says in 66. He writes this book, a very influential book, The Antitrust Paradox. And he says, this is the 78 version. The Sherman Act was clearly presented and debated as a consumer welfare prescription. There's an epilogue in the 1993 version. In the 1993 version, he says, look, here's what I meant by that. The argument of this book, of course, is that competition must be understood as a maximization of consumer welfare, or if you prefer, economic efficiency. Okay, well, once again, I don't think I need that word consumer. I'm not sure I need the word welfare. So what are those doing? And again, you've seen a sense of the art. Consumers in the original Sherman version doesn't make it into the version that actually gets enacted. Then he goes on, the goal is to maximum economic efficiency, to make us as wealthy as possible. So here is, as it were, the beginning, or at least a critical spot. 66 article, the 78 book. And he's sort of all over the map on it. And I don't think you would walk away from this based on what I've shown you. I hope it's representative. Of any sense that somehow consumers loom larger than farmers, loom larger than workers, go down your list. I don't know who your list is. But I don't think you would walk away and somehow say, oh, consumers, we just mean people, buying Diet Coke, right? Those are the people we're trying to take care of. Though, just to be clear, we should take care of people who buy Diet Coke, right? That should be high on our list of things we worry about. Okay. So that's Bork. And then, Bork is successful in the sense that these ideas work their way into the Supreme Court. So the first real run at this is a case called Ryder versus Sonotone. I don't teach it. I assume Eric doesn't teach it. It's just not that significant. Though when you go back and look at it, obviously I did, what's sort of intriguing about it is that the question that is presented is whether consumers are even eligible for the damages in, well, it says Section 4 of the Clayton Act. That was Section 7 of the Sherman Act, so it's the provision that I effectively shown you, where the language of Section 4 focuses on harm to business or property. And someone walks in and says, oh, ordinary consumers, when they buy stuff at higher prices, that's not a harm to business or property. Therefore, they're not eligible for damages. That's the issue in front of the court. And in an 8-0 decision, the court says, nah, they're obviously covered. And they go to the legislative history. And they say, look, it was crystal clear, that's what they intended. They cared about consumers. On the contrary, the floor debate suggests that Congress designed the Sherman Act as a consumer welfare prescription. Seaborn. So this decision certainly doesn't resolve anything about, the scope of the consumer welfare standard, the exclusivity. What I mean by exclusivity, consumers, yes. Laborers, no. No. Workers, no. Nothing like that at all. It's really, in some sense, quite ironically, whether consumers can even get damages. And unsurprisingly, zip, they say yes. Okay, that was 79. Now we're to 1984, right? We're just getting to the edge of Easterbrook writing this paper. Okay, so that's where I want to be. This is the NCAA versus Oklahoma case. This is the college TV football case that you may remember, I hope, from antitrust. Arguing on behalf of the NCAA, a gentleman named Frank Easterbrook. So Frank had obviously had a distinguished career at the Solicitor General's office. And so Frank represents the NCAA here. Loses. So, I never, when we play cards at my house, winning with good cards, sort of anyone can do in that. Winning with bad cards, that's the trick, right? That's what you sort of admire. I don't know if Frank had good or bad cards here. So I can't assess that. But it is noteworthy that that's who was here. NCAA versus Oklahoma, I think hits consumer preference pretty hard. In some sense, if you look through the entire Supreme Court opus, and I did, though I won't show you those slides, they say, look, things that are unresponsive to consumer preference, we should regard that as a problem. And now they cite Ryder versus Sonotone for this consumer welfare prescription. They dropped Bork, actually, or maybe I did, I don't know for sure. But now that's where we've gotten to. And as you trace the arc of the consumer welfare standard forward, though Frank, obviously, this is what Frank had seen, it really becomes an ill-defined but accepted part of antitrust jurisprudence. All right. That's Act 1. Act 2. So Easterbrook's paper, The Limits of Antitrust. So he says, here's what I'm worried about. He's a court skeptic. You'll see that here in a little bit. Fairly colorfully a court skeptic. He's sort of a skeptic of everyone else, too. You'll see that, too. Here's what he says, though. And now he's staring at the history of antitrust. And that history of antitrust had been a decent number of practices which were condemned as per se illegal. You cannot do them. That's a clean rule. It means you don't have to fight about things like market definition or market power. You don't really have to assess the practice in the moment. So there'd been this history of per se illegality. And as you know, the way I teach it in class, I assume Eric does roughly the same thing, is we've backed away from that over time. Pushed more things into the rule of reason. Here's what he says, though. He says, look, when judges condemn something as per se illegal, that practice is dead. And we sort of, and if you get it wrong, if they're wrong, well, how would you revive that practice? It's been put on the illegal list. So he's very concerned about courts doing that. And on the other side, he says, look, if they let the practice go, it's not such a big deal. Monopoly is self-destructive. Monopoly prices eventually attract entry. The truth is, long run, maybe a long time coming, lost to society in the interim. The central purpose of antitrust is to speed up the arrival of the long run. There's a lot there, right? Monopoly is self-destructive. Monopoly prices eventually attract entry. Doesn't, I think, really cite anything for that. And part of what I try to do in class, certainly, emphasize across the quarter, is where do we think market power comes from and why? Right? If that's the thing which animates antitrust, where does it come from? Certainly the conception of Section 1 is that firms can get together and form cartels. And we say, no, you can't do that. That's per se illegal. Price fixing. That's true for prices to be vis-a-vis consumers. It's true for wages vis-a-vis workers. Can't do that. Okay, so we understand those, and we've got a mechanism, Section 1, to intervene on those. Maybe he's saying cartels break down? I don't know, and he doesn't say cartels. So if we're talking about when we say monopoly is self-destructive, if we're talking about firms that grow organically and become monopolies, whoa, you want to say, what are your examples, right? Antitrust, I teach Google. You look at Google's market share in search across the planet. Man, it's in the 90s, and steady at that. Stat Counter. I have too many slides from Stat Counter. They put out all sorts of information like this. It's sort of shocking. And when you say those prices attract entry, wow. You get up in the morning and you say, Google, Monopoly, it's had a good run. I'm going after them. And you go, maybe I won't get out of bed. But more likely what you do is you say, I've got this other market I can go chase. Right? I have a skill set. Attacking incumbents in the heart of their market, I think, is really hard. If you ask what happens over time is people build over here and then maybe they attack it. Right? We're obviously at sort of an interesting moment in search with the rise of ChatGPT and the like. Okay, Bing's gotten a little bump so far. We'll see where that goes. And when I think of monopolies, we read the Alcoa case in antitrust. Alcoa starts, as you all know probably, from government patents. And those patents, that's a good way to get a monopoly, and a way we encourage. That's the system we design. And most patents are worthless, but some aren't. Some are really, really good and valuable. And then they build on that. And so the Alcoa monopoly sort of goes away because of World War II. The government says, we need a bunch of aluminum. We're gonna build plants. You're gonna run them. They get done with World War II, and they go, we've got all these plants. Let's sell some to other people, right? So I expressed some skepticism about this. So, he seemed sure. Monopoly is self-destructive. And then the Supreme Court opinions don't go away. That's true, though things get reversed, overturned, right? So you can think through that. So he's got this balance, though, of mistakes. What types of mistakes do you want to make where he thinks that there is a market discipline for bad practices and that there's no market discipline in the Supreme Court? Though, do note, antitrust, it's a statute. Congress can pass whatever laws it wants to, right? So if Congress says, Amex, don't like it, pass the statute, right? They can do that in a heartbeat. Okay. And then if you ask Frank, why do you think that about monopoly? He talks about it a little bit. He says, transportation costs have dropped. So maybe a lot of the local monopolies we had have gone away. World markets, so he seems a little unconcerned. Now it's 1984. And as we look at the world, of course, I think, so much of it is shaped by our perception of the digital world, right? And Frank's writing in 1984. He's got a reference in the article, but I go, oh my God, really? And that reference is, he talks about the Commodore 64 computer. So we are back in time. There's what is thought of, if you are a computer historian, 3 computers released in roughly 1977. The Apple II, the Commodore 64, and Radio Shack had one. So we're early. He references that, and then you go, as I must, you go to ProQuest. And everyone knows who's taking classes from me, I love ProQuest. Historical newspapers, databases. Sherry's in the back, our head librarian, right? ProQuest is fantastic. And usually when I run a search on ProQuest, I completely ignore the ads. But this is fantastic, right? So the ability to go back and look at what the state of the computer market looked like, roughly contemporaneous to when Frank was publishing this piece. Great, that's what I did. So the Commodore 64, it's sort of like a computer built into the keyboard, I guess. You supply your own monitor. That's the price if you buy a printer, so I don't know what to make of that. The IBM PC and XT. There was an era in which we all persuaded ourselves you didn't really need color for computers. Black and white was just fine. Come on. But why do you fancy people need color? Yeah, okay. And so, there is no color initially. Now we're up to a point where you can get an IBM PC with either monochrome or color. Got to call or write for the price. Email's not a thing yet. Really? You're going to send them a letter, a postcard? I don't know. Note 64K is the memory K, not megabyte, not gigabyte, K, kilobyte. And there is no hard drive. If you want a hard drive, and now they'll tell you the price of that, they're apparently not afraid of this price. 10 megabyte hard drive, $3,500. Whoa! Right? Yeah, exactly. Do we not live in better times? Okay. And then elsewhere on the ad, you see what was called a portable computer back then. Compaq builds this very successful business with these devices that, were fantastic. I never go, oh, look at the idiots. No, these were, in the moment, fantastic devices. Okay, so that's the world Frank is staring at, just to make sure you get the dates. Windows 1.0 isn't released for another year, right? So when Frank is looking at the monopolies, very much staring at the physical world, phrases like network externalities, that's not really part of the conversation. Two-sided markets, not the conversation, right? So the digital world we live in, you stare at things like Google's market share and you go, that seems pretty solid. Microsoft's desktop market share, pretty solid on the personal computer. So this confidence that Frank has about monopoly being self-destructive, I'm not sure what we should have seen then. I'm not sure what we would see now. Okay. Antitrust is costly. Judges act with imperfect information. The costs of action and information are the limits of antitrust. How should we respond to that? Okay. Judges are imperfect. The rest of us are too. But yeah, sure. Look, what I say to people, I always say, I think being a district court judge, federal district court judge, what a tough job, right? I feel like I'm, on the whole, reasonably smart, and I work hard. And most days I go, I think I barely understand the stuff I'm supposed to really understand, right? Now what you do is you say, here are 10 different subjects you need to deal with today and make decisions on. I think it's a really hard job. So when they act with imperfect information, they absolutely do. But the structure of the job we've put in front of them is a really hard job. Now, Frank is saying, and this seems right, that when you build your legal system, you need to make sure that you understand how it's actually going to get implemented on the ground. Who are these judges and what can they do? Okay, that's fair. Then he talks about the market. And I said earlier that, Frank is pretty skeptical of everything. So he says, look, businesses, they just try stuff at random. They don't necessarily know. How do they tell? They try some. They figure out what's helping, what's not, or they go away. So it's not that Frank says people in the market, oh, they know what they're doing. But the market process, the process of competition, that's what then tells us, gives us feedback. And I think part of what animates this paper for Frank is the idea that the Supreme Court doesn't get a lot of feedback, right? While the market is this built-in feedback mechanism. So even as firms, they most of his stuff may be really hard to explain. But the competitive process, which is why we care so much about it, and antitrust, that's what we want to take care of and work with. Then he says, here's the problem. So the problem is with the judicial system, it's not that judges are just imperfect. Okay. But successful competition is almost certainly going to hurt some firms, right? And they're going to say, wait a second, this isn't legitimate competition. And what do? They hire lawyers who know less about the business than the people they represent. That's you all. My experience is I'm a big fan of you all. Lawyers are smart and hardworking. I think they actually understand a decent amount. So, and the process we go through here, back and forth, that's pretty good to interrogate, the people running a business. So, okay. The judges know even less about the business than the lawyers. So it's, people in the market don't really know why it worked. They just see that it works. Lawyers try to understand it. They don't know as much. Okay, so that's not a good story. So he comes to a bottom line The legal system should be designed to minimize the total costs of anti-competitive practices that escape condemnation, competitive practices that are condemned or deterred in the system itself. Okay. Well, this process I've been describing, what the competitive process does, that's what Frank believes in. One need not pretend that markets work perfectly to see that they are better than judges at penalizing inappropriate conduct. So Frank wants to work against that system. He says, you'll see in a little bit here, he says, per se illegal, that's not a great framework. Rule of reason, that doesn't work. I got 5 filters. I'm not going to spend too much time on these. He says, figure out whether there's market power. That's in some sense right, if doable, right? Firms that don't have market power, why should we care what they do? Let them do what they do. If they have market power, then we might be interested. Is it harming, he says, consumers? I hope he's got a broader conception of that other than consumers. That may just be a shorthand for him. That's the consumer welfare shorthand, I guess. Certainly shouldn't think of that as being limited to consumers. He says one of the things that we should pay attention to is how much heterogeneity there is in the market. Heterogeneity is a sign of competition and richness where the competitive process can work. Pay a lot of attention to whether output is dropping. And then ask, is someone complaining? Who's the plaintiff? When competitors show up, ignore them. I got to say I don't agree with that one. I understand the idea behind it, and Frank's built that out here and saying there are always going to be people who are losers in the competitive process and they're going to want to come in and complain. They also understand the business better than most consumers. So that makes them situated to show up and say things. The job of the regulators, the antitrust authorities, is to listen with a careful ear, I think. All right. So per se illegality doesn't work, real reason doesn't make, do the filters, that's the thing we ought to do here. We shouldn't engage in case by case. That's the paper. Where do we go from that? Act 3. So the Alston decision, I'll stop for a second. Questions, thoughts around the room. Anyone want to say something so far? Hearing none, I'll continue. The Alston decision is the second NCAA decision, as it were. Big win for the athletes. And even as that happened, I tweeted about this opinion when it came out, and I pulled out like 10 quotes that I said the defense bar are going to love. Twitter, I'm sad about Twitter. But, we'll see if it survives the Elon incursion. But Alston, talks very much about the limits of judges. Very, very aware of, what judges can do and how that compares to the market. Antitrust courts must give wide berth to business judgments before finding liability. Judges must be wary, too, of the temptation to specify the proper price, quantity, and other terms of dealing, cognizant that they are neither economic nor industry experts. Can't enforce these decrees day to day, nor should any court impose a duty that it cannot explain adequately, reasonably supervise lousy central planners. So the central animating idea behind Easterbrook's piece, which I think are maybe 2, what judges can do well and not, and what markets can do well. You still see that in Alston. So in that sense, I don't say, Frank caused that. I have no idea on that. I'm sure people were critical of judges pre-Frank and post-Frank, as it were. But you still see that very much in Alston. Okay. So, but there is movement afoot. That's, I guess, what I should say. And so if you ask what the limits of antitrust are today, even as the judicial system still seems to be subject to the same issues that Frank identified in 1984, There are different ways to run at competition issues that are not necessarily, at the dead core of antitrust. So President Biden issued an executive order fairly early on in his, running term. And he talks about, fair, open, and competitive marketplaces. Very clear about talking about who those marketplaces are supposed to work for. I always, I know that when someone writes this, it is written quite carefully. We see workers here, small business and farmers here, entrepreneurs here, consumers here. Big business, nope, they weren't there. Let me go back. No, they're not there. Right? So you see a large number of groups mentioned, and you see a sequence of people being mentioned there. Right? It's not as if I would say any of these groups should be somehow excluded from the consumer welfare standard as one might think of it. Again, don't get focused on consumer, don't get focused on welfare. Think of it as a kind of defense of competition. The original language from Sherman, full and free competition, that's pretty good language. But this is obviously an effort to make sure that the competitive economy works for everyone, maybe other than the targets of it. And they say, look, antitrust, we're going to run hard at it. Labor markets, agricultural markets. I thought this was interesting. I'm a lawyer. I obsess about these things. I thought by this point we'd gone to small I internet, right? But there's still an old school capital I internet. Internet platform industries, healthcare, and the like. That's what we're going to do. And the really critical animating idea behind this is what they call a whole of government approach. And the whole of government approach means that we should look through different statutes that might not be antitrust statutes. And we think a lot of those are statutes that and I know nothing about these statutes, so I don't know to what extent the reading to get to this point is a fair reading, the reading's aggressive, I just don't know. But the conception is that there are lots of statutes that agencies are in charge of that, depending on how you make decisions, you can shape competition. That's what the whole of government approach has in mind. We should do that. Okay, they list some of those statutes. So the Packers and Stockyards Act, that's a classic. Bank mergers, telecommunications, down the list. And so look at those, not subject to the antitrust regime, which I've just described, which is fundamentally a fault-based regime. You've got to do something bad, run at that. And that's the whole of government approach. Let's create an administrative apparatus. There is a way in which you tell how seriously you take something, I fear, by how many administrators you have doing it. The growth of the administrative state, well, I was going to say in the United States, we could say in colleges, universities, okay. But they create this White House Competition Council, so people who are sitting in the White House, as it were, who are top of mind for them is this question of overconcentration, monopolization, unfair competition. Work with agencies. Okay, so again, be outside, at least as an initial cut, the judiciary. Don't say, let's file a complaint, right, and bring the judges in. Let's be elsewhere. They've got some particular targets in mind. This is sort of, what else would you say? Antitrust laws fairly and vigorously. The merger guidelines are a target. This Stigler Center conference, Thursday and Friday. I mean, everyone wants to know where the guidelines are. They seem to be held up. I don't know what that means. Does that mean they're having trouble coming to closure on it? I don't know. But the guidelines are going to be interesting to see what they do. But that was one of the targets of the executive order as well. And then FTC rulemaking. So There are questions about the scope of the FTC's rulemaking authority. We're going to litigate all of that. That's, high-level, major questions type stuff. It's much more fine-grained. What does this language, unfair methods of competition, mean? They've got this Section 6 rulemaking power. Is that substantive? Is it really more administrative? All of that's going to get litigated. But in the meantime, run at it. Let's do that. With regard to non-compete clauses, and then with regard to data and other things and major internet marketplaces. So again, a process that would eventually get to the courts, but wouldn't be organized around the courts, right? It would be organized around an administrative process. And indeed, well, we'll get there in just a second. So this is happening. I didn't go out and read this report, promoting fair competition and innovation in seeds and other agricultural input industries, but I didn't read it. So, but I'll urge you to read it. I mean, what I mean by that is, it's all a question of time. I never find something like this uninteresting. Never, ever, ever. Right? You head into a little, that's what the nice thing about being a lawyer. You head into a little world and you get embedded in it. You look around and the people working in that are smart, and then, seeds, agriculture, I care a lot about that. So I haven't read this, but it's exactly the kind of move. And there's this whole IP layer here that I go, whoa, what is that? That I should probably go look at. I assume we're talking patents there. But exactly this conception of agencies have authority, they can make choices, those choices can shape competition. That's what we ought to be doing. And again, outside the judiciary, so if the central limit that one takes away from the limits of antitrust is the inability of judges to do things. Well, maybe you're going to say, well, this is all capture. Maybe, I don't know, right? I don't know. So it's not as if I go, oh, agencies, that's perfect. Congress, perfect, I know. But they have more time, right? Again, think of the district court judge having to do 10 different things each day. Hard. All right. And now to the FTC proper. So the FTC issued a statement in 2015 on unfair methods of competition. So remember the language of Section 5 of the Federal Trade Commission Act. The original language in 1914 focuses on unfair methods of competition. That language is amended in 1938 to pick up unfair and deceptive acts and practices. There are some subsequent amendments which clearly have consequences for the rulemaking authority, comma, if any, comma, under both sections, Magnuson-Moss. I'll just say that and move on. But the whole idea of an unfair method of competition, well, how should we think about it? How does it relate to the rest of antitrust? And the FTC issues this a statement, not a rulemaking, statement, and says, look, consumer welfare, that's what it means. So Josh Wright, George Mason professor, then before, commissioner briefly, I know was pushing hard for this. We're going to do the rule of reason, and we're going to sort of focus on traditional antitrust issues. So a way of controlling Section 5. That is not the current regime. So the current regime issued this statement about Section 5, as you can see, in November of 2022. They'd already killed off the 2015 statement, so that's dead and buried. And they say, look, here's what we want to do. We should focus on something which is a method of competition that's unfair. Okay, it's hard to fight that. That is what the language, after all, says. But what does that mean? And they say it's not just competition on the merits. And then they start to say things like coercive, exploitative, collusive, abusive, deceptive, predatory, economic power of a similar nature. And then they've taken that idea to here. So the FTC has issued a rulemaking, this is their first substantive rulemaking forever, maybe, on non-compete agreements. And so the comment period on that closed maybe last week. So this is going to be the first run at using statutory substantive rulemaking to get rid of a practice. Now, look, I think you should think of that as a return to per se illegality, but through a different path, right? I think that's what it is. It's to say this practice is bad. Not all of them, but most of them. And so it's not as if having practices that were off the table is a new idea to us. That's what per se illegality was, after all. But it is a different path to getting there, right? And again, if you're asking what are the limits of antitrust, and if those limits are about the judiciary, well, this is a different approach, right? Where let's say we're going to do it, and everything I said about, well, what kind of powers do they have, that's going to be put on the table. I wrote a little piece for ProMarket on this, which, if you want to know what those views look like, you can go read them. I have to say, and I'm basing this on Easterbrook's 1984 piece. I wrote this piece because they asked me to write something on it. Bless you. And I said, I don't think I know anything about what that language really means. Let's go dig into it, right? That's how I think. So great. And that turned out to be, I thought, surprisingly interesting. And I think the FTC's core authority there is certainly more limited than they think it is. But we're going to fight about all of that. That's how I looked when I was writing the piece. That is what that's supposed to capture, with the appropriate seriousness and vacant eyes associated with best scholarship. Okay, so that's one path here. I want to try a different path. So the other path is we pass new legislation. That's what we do. So we go judges. Well, we've given them these pretty open-ended, vague standards in Section 1 and Section 2. Section 5, Federal Trade Commission Act, pretty open-ended. You got to go work and see if there are limits. That's what I did a little bit in that piece. Let's give them new laws. And that's what you're seeing across the world. So Europe passed the Digital Market Act, the Digital Services Act. As I criticized Twitter, I woke up this morning and learned on Twitter that the initial designations of VLOPs, very large online platforms, into the DSA was happening today, I gather. I saw a list of firms. I could have built that slide, but didn't. So the DMA and the DSA, very different approaches, and consistent with what I'm going to show you here, which, again, for those of you who took the antitrust class we've seen before, is an idea that says we shouldn't be spending a lot of time, or at least on some firms, and I think they have 19 VLOPs that they've designated. We shouldn't be spending a lot of time figuring out whether they have market power or not. We're going to have an administrator say, yep, they've got it, and then act accordingly. The UK this morning, today, I guess, announced draft legislation, I think, to do the same, so I've not looked at that yet. In the United States, last Senate, last Congress, I should say, we ran very hard at legislation. Senator Klobuchar, my law school classmate, we were on law review together. So as you're looking around the room, remember, these people may turn into something. Someone's back there saying, yeah, that's me, okay. She's got a book on antitrust. She's quite serious about it. Okay, so the American Innovation and Choice Online Act, the core of it is very much like what I just described to you about the DMA and the DSA, which is to say, here are the firms we care about. Okay, what to do about them? Well, we're going to add some new substantive violations. Self-preferencing. So you open an iPhone, and it comes with a variety of apps up front. It can only use the Apple App Store, at least in the United States. It's going to change in Europe. It comes with the built-in weather app. which I looked at this morning. I walked to work, and I don't like to walk in the rain. So I quickly studied, and it guaranteed me that at 54 minutes out, the rain would end, and I could come to work. Okay, great. So all of that's pre-installed. There's no question that firms trying to compete in the weather space or in the music space, Spotify, say, Apple has, Google has, with Android, a huge advantage if they can pre-install all of those apps. So let's regulate that, make it unlawful for them to do that. Self-preferencing. Discrimination. Don't let them, discriminate in terms of how they apply terms. Discrimination is one of the classic approaches to natural monopoly or small N type markets. So Sherman Act's passed in 1890. Interstate Commerce Act is passed in 1887. So contemporaneous, right together. The Interstate Commerce Act very much talks about non-discrimination. That is at the core of the Interstate Commerce Act. And if you look at other areas, I have this platforms course that gets taught sometimes, you'll see all of that there. It's not what the Sherman Act did. But now, as we again say, well, maybe the limits of antitrust are too binding, too constraining. Maybe we want to, maybe these firms, Apple, maybe they haven't done anything wrong, but we still want to regulate them, right? That's sort of a democratic choice. We hope they're going to be made thoughtfully. We'll talk about that in just a second. But it is to recognize that antitrust has constraints, and that if you want more, maybe you want to go elsewhere. And so that's what's happening. We haven't done that yet quite in the United States, but certainly happening elsewhere. Now, there's another perspective on that. So the epic Apple Ninth Circuit decision came out yesterday. I haven't read all of it. I'm up to page, I don't know, I'm deep into the 70s. So if you're into this, you should definitely read it. It's an interesting decision. It's absolutely an interesting decision. Mainly an affirmance of the lower court decision. But what I wanted to highlight from it, and I've got a typo in the slide, that should be competition, top, is what they say. So the case, as you may know, is about Epic, the makers of Fortnite and other games. They have their own platforms. They clearly want to be a player in the metaverse that we all will live in. Well, who knows, right? That's a different discussion. AI seems to be moving faster than the metaverse, so maybe it'll all come together. Epic is unhappy that when people buy V-Bucks, which is the internal currency of Fortnite, I gather, that Apple gets a 30% cut of it. And so Fortnite, Epic would like to be able to do these purchases outside of the constraints of the App Store, not pay the fee. And they would like to have their own App Store that ran on iOS as well. So they brought a complaint against Apple simultaneously against Google. The Apple case is much farther ahead than the Google case. So the Ninth Circuit now is looking at these practices and says, look, Apple and Google have taken different approaches on this. Google, you can sideload. Google, you can have other app stores. If you want that, go get it. I wrote a little piece about that somewhere. The evidence I saw suggested that there was much more malware in the Android ecosystem, and that the people who had studied that attributed that to the ability to have other app stores. Part of what Apple is selling is privacy and security. That's part of its competitive advantage. And the court yesterday, right, it's a 2-1 decision, said, look, Apple's restrictions create a heterogeneous market for app transaction platform, which as a result increases inter-brand competition, primary goal of antitrust law. They recognize, good for them, I think, that Google and Apple are in competition with each other over this. It's not as if there aren't a zillion Android devices. And so the question one might ask, the question I would ask my classmate Amy is she wants to effectively force Apple to allow other app stores to have your own app store and exclusively your own app store, the kind of discrimination, kind of self-preferencing. Why? Right? Consumers choose. Why do we want to choose one business model? If we're going to choose one business model, why that one? But that's what democracies get to do, right? So we don't do that internally in antitrust, and indeed doing so, violates Ninth Circuit yesterday, the primary goal of antitrust. All right, I've got one more thing I want to do here, and then I'll be done. So let's try a different angle. And this is a speech that the head of competition in the EU, Vestager, gave less than a week ago. She is, as you know, a very prominent figure, has been for, I won't get the date right, at least 5-7 years in European antitrust. And so the question comes up, how should we think about the overlap between antitrust and climate, right? What are the boundaries of antitrust? What are the limits of antitrust? Will traditional antitrust approaches somehow make it harder for us, Europe in this particular situation, to run it the green transition, as she wants to talk about it? So that's what she's going to talk about. That's what she does. It's not that long a piece. I think it's like 3 pages. And she says, look, and now I don't know what she says. She says, on the one hand, we should allow some joint purchases of gas. At the same time, our role is to make sure that private cooperation through the platform fully respects competition rules. Okay, she's super sophisticated, right? In antitrust, we've talked about situations where, standard essential patents and the like, where private parties come together and create things, and maybe allowing them to do that subject to the right restraints is exactly the right social outcome. That's what she seems to be saying here on this new EU energy platform, which I guess is just opening. But she's aware, and it's at this level of generality. I think it's hard to know how to assess that. I mean, she's saying the right words. It's implementing it in reality that's the hard point. Wants to benefit consumers. Again, I assume that word consumers, she means everybody, I assume. That's interesting, though, how she phrased it, right? Go back and compare the Biden executive order, which is very careful to go down this list of people who might be affected by competition. Antitrust rules should support the green transition. But when an entire industry aims to become more sustainable, the very mechanism by which competition keeps prices low can make the transition more difficult. If a company must incur higher costs in order to achieve a better sustainability outcome, it can face the first mover disadvantage. The more competitive the market, the greater this disadvantage can be. That means there are times when cooperation can be a good thing. Okay. So I think, this is, I offer this as an example. We've had other situations like this. Yes, exactly. It is not unusual for people to come forward and say, we should be able to form a cartel. Here's why it's a good thing. So American universities have done that. There is pending antitrust litigation on that issue. As you may have seen, I saw this while I was sitting at the Stigler Center hearing. I gather the University of Chicago settled either Thursday or Friday. I see some nods around the room. That's not public. I don't know anything about it. So I guess we'll see what's going to happen there. But it's not, bigger point, it's not unusual for groups to come forward and say, we should get an exemption from antitrust. What we're trying to do is a good thing. And getting that right is, I think, super hard. We want to do this, but no greenwashing. The last thing Europe needs is cartels using sustainability as a cover for illegal collusion. Again, the limits of antitrust, can we get that right? That is the talk. So thank you. Questions, comments, thoughts? We've got 5 minutes before people want to come in here. Please, please.
So this speaks to I guess, the limits of antitrust law and the possibilities of legislation. So I'm wondering, my understanding is that the antitrust law responds to a very particular moment and economic trend. Like the trust was an actual organization that they were trying to forbid.
Clever lawyers like you all, looking at the situations of the time, business lawyers doing deals. A man named Sam Dodd said, I've got a tool, I know you've got a business objective, let's do this. That was a trust. Okay.
Yeah. Well, so I'm wondering if, people sometimes compare that era to our era.
Yeah.
Like this, Tim Wu's, New Gilded Age. And I'm wondering if that's, if that's accurate. If our large conglomerations of capital are similar to the trusts of that time, or if there's something different about corporate power today than what it looks like.
Yeah, that's a great question. So look, I know what I know about, and I know what I don't know about. So the industries I focus on are these digital industries. Those are industries where, and I'm writing this book, and that's the 20,000 words, and okay, where, you can trace out how they got to where they are. And those are not industries typically where we took a bunch of existing competitors, put them in a trust and said, don't compete. These are things that have grown organically. So I think understanding how one responds to firms that have not done anything wrong necessarily, that have built products that we love and that have succeeded in the marketplace, it's fine for us to say, well, we don't think antitrust deals well with that. We need a different tool. But I think we ought to recognize what we're doing. Yeah. Other questions? 4 minutes. Please here and then here.
I was wondering, how do you think about potential conflicts in antitrust law? Like the DMA seems much more onerous than our regime right now. These companies operate.
Absolutely.
Everywhere you could take that to the state level. Like if states start passing their own antitrust laws and really trying to force action, what do we do then?
Yeah. So it's interesting. So if you read the editorial page of the Wall Street Journal, I sent one of those to my daughter. She goes, who are these people? Because that's not what she reads. They've been complaining that the current chair of the FTC, Lena Khan, recognizing limits on her authority, is basically trying to get Europe to do everything, right? So this idea of a kind of forum shopping, and that's sort of what you're describing. I will say I won't say whom, I had a conversation, I'm willing to, I don't consult much. And I'm delighted to have a one pro bono conversation with virtually anyone. And I had such a conversation with the state in the last 2 months. And that was so interesting in the sense of trying to understand what would motivate them to bring a lawsuit, right? You've got the FTC, you've got DOJ, it's going to be money, they've got a limited budget. And so, me personally, I guess I'm probably more of a centralizer on that. And you do read stories. Some of the stuff I was writing recently, there's a situation where they hold these hearings it's the purchase, Google's purchase of DoubleClick. There's a congressional hearing on it, and at the end of the hearing, not a lot happens. Though Google does make a promise to Senator Schumer that they will put more employees in New York. Yeah, duh, right? So, and that's what you see, I think, sometimes with attorney generals. The case will get settled, and I don't find that attractive. And what to do about it? I don't have a clue what to do with it. Maybe one more. Yeah, exactly.
You talk about how this doctrine, the whole idea or part of it, comes from the monopolies being self-destructive.
That's what he says.
You change that because that is basically unsupported.
Okay. Frank's in the building. You go talk to Frank.
You change that again, change the position. The markets are actually monopolies and non-self-destructive. But self-returning to market power and non-market power.
Yeah.
How would that affect the tools?
So,
regarding antitrust and the whole government approach versus
Yes.
the statutory
Sure.
and the judicial approach.
So a couple thoughts on that. So I didn't go to the dinner at the first night of the conference. I had dinner with my wife. Always have dinner with your wife. But at the dinner, there was a session with Judges Wood and Easterbrook. Did you go to that? Oh, you went to it. So you can tell us what happened. I haven't watched it. So the person who was doing the interviewing is a former JSD student here. So I had exchanged a few emails with him, and I said, ask Frank about this durability of monopoly point. What did Frank say?
I don't remember.
Yeah, okay. And an hour from now, you're going to say, I went to the talk. I'm not sure what Picker said either, but okay. Right? I understand. I get it. So in terms of the tools, right, what does it do to the tools? Look, I think the more you think the market is not going to correct, the more you want to call out for other tools. And I think that's what we're seeing with regard to things like the DMA, DSA, the UK this morning, and that's what you're seeing there. So again, the advantage of that is that at least it's a democratic process at work. I think we're out of time. Thanks for coming. I really appreciate it. Eager to see you all back in the classrooms with me in the fall, even if you're graduating. Yeah, okay.